It's time to start. Welcome everyone to our online event, which is a part of the 12th annual conference on resolution of CIS-related business disputes run by the American Bar Association with the Russian Arbitration Association. This time online with a very intense program. Welcome to our session, which is devoted to the COVID-related real estate disputes. We'll be discussing how the pandemic has impacted the way we approach dispute in real estate and lease disputes in particular. Let me introduce my co-panelists, or better, let's do it more interactive. Let's ask the co-panelists to introduce themselves. So let's start with Amanda.
Good afternoon. I'm Amanda McNeil. I'm a partner at Howard Kennedy Solicitors in London, and I head up the real estate dispute team.
Thanks, Amanda. David?
Hi, good afternoon or morning from my desk here in Atlanta, Georgia, in the United States, where I practice with the firm of Arnall, Gregory, and lead our retail industry team. I'm a real estate litigator and have been dealing with these COVID-related real estate disputes for the last 6 months. So welcome.
And Aleksandr.
Good morning, everybody. My name is Aleksandr. So I'm a senior lawyer in Mango, well-known fashion retailer, and I'm in charge of real estate issues and corporate issues. So last 6 months, as David said, we had a lot of fun with COVID things.
And I'm Andrey Zelenin, managing partner at Lidings, Moscow, Russia, involved in dispute resolution and in particular resolution of real estate dispute for our clients in Russia. Probably we should thank a very distinguished panel of conference sponsors. You'd see them on the slides, which made this event possible to happen. And also I need to add a few housekeeping notes for those who has already joined us. Anyone who has used the link to access the event can use the chat, the Zoom chat, to ask questions. And for those who want to join the discussion and want to comment something in live format, they can use the raise your hand button in Zoom. So we'd be able to reclassify you as a member of the discussion group. So you'd be able to speak up and share your experience of resolving real estate disputes resulting from the COVID pandemic. So let's go further. Oh, by the way, that's the slide that I was supposed to show while we're introducing each other. Let's go to the plan. We have roughly 45 minutes to cover a number of important topics. You can see them on the slide now. And what we do, given that we have this multinational team present, would be taking each of the topic and discussing that from the perspective of the respective jurisdiction. So this is how it would look like on the slides. So we can start with the protection for tenants granted by the governments as a result of fighting against COVID and its aftermath. Well, probably I can start here with a short overview of what's been happening in Russia. Like the Russian attendees surely know that the government has and the legislature has acted very actively and generated a lot of new regulations related to measures to protect the nation against COVID, and that was not only lockdowns, but a lot of new requirements at various levels of business. Interestingly enough, despite the pandemic, our parliament, the State Duma, was fast enough to adopt a special law. And among other provisions, it had a special clause related to additional rights for tenants in leases. Two principal issues were covered. First one was connected to deferrals. So if a tenant belongs to the impacted sectors, there is a list of those sectors, including retail, aviation, etc., etc. They can ask, they're entitled, actually, it's not that they can ask, they're entitled for a deferral, which can be to some extent provided automatically on their request to the landlord. For a broader list of tenants, there is a provision that they could ask for an abatement, a decrease of rental payments. But the wording of the law is not perfect, so there is no corresponding obligation of the landlord to provide such an abatement. Probably when that has been recognized by the lawmakers, another law has been passed that said that in case the tenant belongs to certain, meets certain criteria, it's small and medium-sized business in impacted sectors, then on the, let's say, in a situation when the tenant and landlord have not reached an agreement on the new size of lease payments, the tenant can terminate the lease and leave the premises without paying any penalties, etc. So that's a short coverage for Russia. Probably, guys, you can go on. David, you start.
Sure. Thanks, Andrey. And there's not a whole lot to say on the United States area here on protection of tenants. We have limited most protections to residential property. There aren't a lot of commercial property restrictions as far as evictions, and there's no mandates from the federal government or even local governments when it comes to deferrals or abatements. Things like that are all a matter of negotiations between the landlord and tenants. There's no laws that really impact that. From a practical point of view, in most cases, even commercial evictions are not going forward very quickly. As we'll talk about maybe a little later, they require a whole court process, and that's been delayed by COVID as courts are only dealing with emergencies. And I know I've got a couple of commercial tenants I represent in Chicago, Illinois, and they would normally have had hearings by now and potentially been dispossessed, but those hearings have been pushed back to November and January, respectively. So in a practical sense, evictions aren't taking place that often, but they certainly are allowed with there's no federal protection. And to the extent there were some local state protections for commercial property, those went away pretty quickly, and they're just letting the parties and the courts resolve those. So not as much being done by our federal government here in the States. Amanda?
So in the UK, the government's introduced laws and regulations to protect both residential and commercial tenants. In relation to residential tenants, there has been a ban on possession proceedings. Any possession proceedings already ongoing are stayed until the end of this month, and proceedings that have not yet been issued cannot be issued until after 30th September. The other point is that with residential possession, you're now required to give 6 months notice to tenants bringing their tenancies to an end, as opposed to previously 2 months. In relation to commercial tenants, there's no government relief that provides that tenants are not liable for payment of rent during the pandemic. but what the government has done is impose restrictions on landlords' remedies to recover rent and other sums due under the lease, and this includes a moratorium on forfeiture, a prohibition to wind up companies, and we'll be discussing that later. The other thing that the government has done, which is certainly significant for those tenants who've got properties in London, which are used for retail or leisure purposes, is that they have given them effectively a property tax holiday for a year. And property rates, property tax in London is really quite significant. So that is a welcome relief for the tenants. Aleksandr.
Thank you. I was observing starting from March, I was observing several countries of Central and how things go in the countries of Central and Eastern Europe, and in most of the countries there were some new laws, special laws created regarding COVID. And it was interesting to observe that in some of the countries they were really fast and they issued new laws, like in Romania, for example. But then there were a lot of amendments, and finally they many times they canceled different they canceled different provisions of laws, and then they issued another one. In some other countries like Czech Republic or Slovakia, they were waiting quite a long period of time, and then they issued like a law, and this law now explains how to act in this or that situation. So, for example, in also what you can see in the slide is that in Poland, for example, it's called anti-crisis shield. They call it like that. And the idea is that you have to provide your landlord with a binding offer, and only in case that if you provide the landlord with this offer, and this offer you say that you agree to make your lease agreement a bit longer for the period of the closure, which was where was the state ban, plus 6 months. So in that case, if you provide the landlord with this kind of offer, the landlord will give you, you will not be obliged to pay the rent for the period of the ban, when all the shopping centers and stores will close according to the law. Otherwise, you have to pay. So in other countries, they just created a special financial scheme of some help of the government and state help to the tenants, and of course there are some certain special conditions which you have to match. So, for example, in Czech Republic or in Slovakia or in Romania as well, but it's there the scheme, the structure of this help is a bit complicated to understand how it works. Also, there was some bans for there was some bankruptcy moratoriums and eviction moratoriums. When I say eviction moratoriums, I mean that in the most of the countries it was prohibited to terminate the lease due to non-payment.
Yeah.
Andrey?
Yeah, thanks, Aleksandr. We definitely go to discuss eviction and bankruptcy moratoriums in more detail. But now what we see is that indeed in various jurisdictions the government has adopted certain measures to help parties to find a balance related to potential disputes resulting from the COVID pandemic. No, that's too fast probably. This next slide. So after thinking of how government cares of us, let's try to discuss what are the contractual instruments in common law and civil law jurisdictions that can be implemented because of the pandemic already, even without the help or prompts from the governments. So let's start with English law, which seems to be the most used on the territory that is covered by this conference.
Okay, so in the UK, most commercial leases don't contain force majeure provisions. And based on previous case law, the courts are unlikely to imply a force majeure provision into the lease. But under English law, there's no standard definition of what a force majeure event is. So consequently, even if a lease contains a force majeure clause, there's no certainty that the pandemic would trigger the application of that clause. So each case is going to turn on the wording of the specific lease. But where force majeure provisions are absent in a lease, it may be possible to exit the lease on the grounds of frustration, but only in very limited circumstances. Impossibility of performance is the key requirement here, and the English courts have set an extremely high bar for holding performance to be impossible. And I mean, just looking at the pandemic, and whilst the pandemic itself and the lockdown is not going to permanently make performance of the lease impossible. I mean, it's just temporary obstacles which will be later removed. But what we are seeing is that the tenants are using potential arguments where the tenancy in hand is particularly short and the lockdown has eaten into a considerable proportion of it, or where a lease contains a restrictive user clause, and because by way of example, the government ordered a closure of all non-essential shops and restaurants, use would have been unlawful by reason of that government order. But these arguments, although they've sort of been thrown out and are sort of doing the rounds, they haven't yet been tested by the courts. I mean, I think the other thing that, certainly in terms for me advising my clients, they often don't want to argue frustration because they don't want the landlord to accept that the lease is frustrated, because they don't actually want it to come to an end. All they're looking for is basically some relief from payment of rent during the pandemic. I mean, certainly what I have been arguing, and others have been arguing for our retail and restaurant clients, and again, this hasn't yet gone before the courts, is a partial frustration. What we're saying is that by reason of the government ordering the closure of non-essential shops and restaurants, we're unable to generate an income required to pay the rent. The modern concept of rent payable under a lease is payment for use and enjoyment of the land demised, and if you can't enjoy the property by reason of the forced closure as a consequence of this unforeseen pandemic, then the lease is partially frustrated. As I say, it remains to be seen whether this argument would succeed in the courts, and I think it's a case of watching this space.
Yeah, thanks, Amanda. That was common law, and I'm really interested. What would the civil law jurisdictions say? Aleksandr, you cover pretty lot of countries, and I see that on the slide you say that it's not everywhere you have force majeure provisions applied on default, so you don't have them in the law. What is the difference in the approach there? Yeah,
the thing is that we were quite surprised when the situation with COVID started. We were quite surprised that in the jurisdictions in Europe, not the common ones, we were told, and we examined, that force majeure does not exist as a general concept, or as Amanda said, it is not defined by, for example, by Polish law. Polish law does not have any definition. And the contract itself, is the most important source for understanding and which events might be qualified as a force majeure and which consequences are correlated with it. So that basically means that in every case you want to apply force majeure clause, you also have to go through the whole contract to read what is exactly written there, and only then you can figure out if you can apply force majeure clause or not. The other interesting thing which is applied, which is used in Central Europe and in Eastern Europe and in Russia, we also have in the civil code, we also have the same concept, is the concept of which is called rebus substantivus. What is that? So basically, it's the old Latin principle, which stipulates that where there has been a fundamental change of circumstances, a party may withdraw from or terminate the deal, the contract. So, and this really works, and we understood that, in fact, yes, the situation with COVID, you definitely can state that this is the rebus substantivus. Well, not in all the countries, but in the majority of the countries in Central Europe, you can say that it was this exactly situation when the circumstances changed that crucially that you could never imagine it could happen. So, and this could be a good legal ground to claim the change of the contract or to even terminate it. Andrey?
Now to David, yeah,
yeah.
And
sure.
David should give us some understanding on whether U.S. is a common law or civil law jurisdiction.
Well, first of all, this is an area of force majeure, frustration, and impossibility of performance where we've been spending a lot of our time debating these issues. We do have some common law that the courts have created over the years to give us some guidelines, although nothing that really applies to a nationwide pandemic of this sort. But we do have some law, and we have plenty of law interpreting force majeure contract provisions. And force majeure in the States is purely a matter of contract law. If it's not in your contract, you have to go to common law doctrines that overlap, and we'll talk about that in a second. But I will say that unlike, I guess, in the UK, most of the leases here do have force majeure clauses. Some of them have to do with the original construction or build out of a retail space, and if that's delayed. And then most of them also have a second force majeure clause that says if something outside the control of the parties prevents performance by either of the parties, and usually there is sort of catch-all language like that, that you don't have to perform your obligations under the contract. Now, where the tenants are really losing their leverage in the States is that even if they have a force majeure clause that does, by its language, apply to COVID, it doesn't often give them any relief when it comes to rent, because we have what we call rent carve-outs, which say that neither party has to do anything under the lease if it's prevented by some force outside their control, except the tenant still has to pay rent no matter what. And that's a provision that the courts will respect as a negotiated agreement between the parties of allocating the risk of this sort of event. Now, if you don't have a force majeure clause in your contract, or if it has one of these carve-outs, you can argue frustration of purpose and impossibility, but that's a very state-by-state law-made doctrine. We have very little federal common law in the States. We have a lot of state-by-state common law, and there are a lot of similarities, but there are a lot of important differences. And the standards for meeting frustration of purpose and impossibility, which really they tend to overlap a lot as far as the courts, when they're discussing them, they'll apply a lot of the same principles. And it is, like Amanda said, in UK, it's a pretty high standard. I would say that depending on where you are, there's sort of a continuum that starts with maybe the lowest standard that only some courts would give you relief for if something's impractical. And I'll use an example in case I'm working on defending a chain of movie theaters that have some very strong COVID-related defenses to not paying their rent. And it's impractical, which is the baseline, because of the health and safety issues. It's tough to show a movie, and this particular chain is also a place where you can get food served to your seat. So it's even more complicated to try and open during COVID. It's what they call a cinema and draft house. And so they've had a lot of problems just with health and safety issues, but that doesn't make it necessarily impossible. And we're arguing and defending them an impossibility defense, which is sort of that second level that a lot of courts will accept as an excuse not to perform on your contract. We would say it's impossible, not just because of the health and safety reasons, but our movie theaters have a rather unique supply chain argument where they don't have any new movies to show. And their leases, because the landlords wanted to make sure they were showing the right movies, they require first-run movies to be shown 85% of the time. So they can't just say we should show old movies. We have to show new movies. Hollywood and the other places have not produced, and if they produce them, the studios won't release them. So they haven't had any new movies. We're saying it's impossible because of the supply chain, which is an argument not available to a lot of restaurants who've been able to get their food, or other businesses, retailers that have been able to get their merchandise, but movie theaters haven't been able to get movies. The third on that continuum after impractical and impossible would be illegal. And again, using the movie theaters for at least the first month, say through May, most states in the United States had stay-at-home orders where you were only allowed to go out for essential activities. And of course, movies weren't included. So it was illegal to open your movie theater for at least a month. And that's the highest level where our courts will give frequent protection. We expect to at least win that first month that we don't have to pay rent on an illegal standard. Whether we can continue to win on impossibility or impracticability, that's not determined yet by the courts. And finally, I'll just say that the analysis in the states is very much dependent on where you are. If you're in the Midwest, it may be closer to normal. If you're in Manhattan in New York, then there's a lot of restrictions and a lot more arguments and defenses available to retailers. Like I said earlier, the type of business, some are being able to survive. A lot of, for example, I have a pizza client that does retail, that does delivery and app-based deliveries. They're back to 2019 levels and even better in some cases. Whereas the movie theaters, the gyms, places like that, they're not doing well at all. And then finally, going back to location, there are very localized shutdown orders. There's no federal orders, but there's a whole, we keep a chart of over 100 different orders of states and cities and what they're saying you're allowed to do and what you're not allowed to do. And most of those over the last few months have been very much relaxed. So I know I went on for a while there, but it's a big issue.
That was
here.
quite an interesting chain of arguments that you used on the example of cinemas. Indeed. Well, I actually, because we need to speed up a bit, I wanted to start a poll. That's the question. You'd now see a pop-up window and you'd be able to vote, to cast your vote. And while you vote, I would say a few words about Russia, because there has been, apart from the activity of the legislature, there's been also a series of so-called clarifications or explanations by the Supreme Court, and they specifically covered force majeure in a very, let's say, light way. So they said that yes, but the force majeure potentially can apply, but it's kind of subject to particular circumstances. And this exactly demonstrates a situation where when COVID can be a force majeure to some industries, while it would not be to others. And it would depend very much on how the case is argued and decided. So I need to show the results. Do you see the results of the poll on your screen?
So somehow the polling got closed, it said, but I think you've opened. You have to relaunch it.
What if we do it once again? Let's try to do that once again.
Yeah, it appears it only lasts a minute. So I guess have to be quick.
Yeah, probably. Okay, so the poll would be here for a while. Let's go to other slides, and we've touched upon eviction already. So I'm inclined to skip Russia here because there's really a little special guidance on eviction related to COVID that we have here, because eviction is obviously a remedy that the landlord has, and for instance, if there is a breach of provisions and delay in rent, the landlord can be entitled to evict the tenant, but the tenant will have for instance, force majeure protection in some instances. So there is no special regulations with respect to that. What about US, UK, and Europe? Is there anything special that has appeared? If not, let's move quicker to other points. We have roughly 20 minutes to go.
So shall I just start and say that in the UK, forfeiture or eviction is one of the most powerful remedies for a landlord for non-payment of rent. The lockdown happened immediately before the March quarter rent fell due. The government ordered a moratorium on forfeiture. Yesterday they extended it until the 31st of December. So that moratorium for forfeiture is only in relation to non-payment of rent and other sums due under the lease, like service charge. So if a tenant is in breach of other clauses in their lease, the landlord still has a right to forfeit. Also, I mean, it's questionable. Whilst I think the moratorium certainly, which was originally up until the 30th of September, gave a very useful breathing space for landlords and tenants to try and negotiate terms, I do question whether now extending it until the 31st of December is economically the right thing, because it may stall negotiations between landlords and tenants. Tenants think that they've got this additional breathing space. Perhaps some tenants will put their sort of head in the sands. For landlords, certainly it's just increasing the pressure, the financial pressure on them, where they've got lending obligations. We've already seen one commercial landlord of shopping malls go into administration, and there are a couple teetering on the edge. So as I say, whilst I think the moratorium was needed, I'm just querying what it's really going to look like the other side at the beginning of next year, and whether we've just basically kicked into the long grass a problem that's going to happen.
Yeah, thanks, Amanda. Aleksandr, will we be adding something other than?
Well, in the European countries, once more, I'm talking about some countries of Central and East Europe. The situation is very similar to the legislation in Russia. It's not like there is a lot of specific legislation on that. However, in some of the countries, like in Romania, like I said, the eviction was prohibited. However, when we were working, and we are still now working with negotiating with some of the landlords where our company is presented, in the shopping centers where our company is presented. So in every contract, in every annex to the lease agreement, we always let's say we always discuss and negotiate this issue, and we try to always like renegotiate some commercial clauses and the date and the payment due dates in order not to be in breach. So, however, from on one hand, legislation of some countries is just very general and says that you're not prohibited, the landlord is prohibited to evict. However, on the contract level, I would say, so both parties, the landlord and the tenant, are trying to negotiate it in the contract exactly, not to be protected.
Okay. David, really quickly on the US.
Sure. Well, to evict a tenant here requires a whole dispossessory process, and they've been pretty stalled. But what I do want to mention is one of the more powerful tools that you have in the U.S. is to lock out a tenant until they pay their rent. And that's different than an eviction. If they are defaulted on their lease, whether it's for rent or something else, you are allowed in most jurisdictions to change the locks, to keep them out. Therefore, their business has to close. And that's not an eviction. You aren't reletting it. You're not removing their possessions. You're not terminating their lease. As soon as they pay their rent, they're allowed back in. So that is something we have seen some of because it's a quick acting remedy. The danger there is that if you do it when you're not allowed to do it, then the tenant has some pretty serious damages accruing for their lost business. And especially with COVID defenses, we're seeing some hesitancy on the part of landlords to take that risk.
I see. So next we have liquidation and bankruptcy. Again, short on Russia, we have a special regulation allowing or introducing a moratorium for initiating new bankruptcy proceedings against debtors in the impacted sectors. And only the debtor himself can kind of waive this moratorium by starting the proceedings voluntarily. Otherwise, there is no way to initiate bankruptcy against a tenant if he's in the impacted sectors, and if there is if you have a claim against him. There was an interesting case recently. A landlord was trying to collect penalties on late payments of rent, and the tenant used the force majeure protection as the first argument, but the court found that he's better protected by the moratorium, and therefore rejected the claimant of the landlord on that ground rather than on the force majeure, based on the force majeure provision. I think I would not be going deeper into the Russian rulings connected to moratorium in bankruptcy, so please go on, colleagues, if you want to cover something on your respective jurisdictions.
I will just quickly add that again, more or less the same in Russia. In the countries, in European countries, there was some general legislation, but we were also with some rules about moratorium. But in our case, we were lucky not to examine this too much and not to face this problem.
So in the UK, there's a ban on presentation of petitions to wind up a company for non-payment of rent, unless the creditors are able to show to the court reasonable grounds for believing that COVID has not had a financial effect on the tenant, or that the tenant would have been unable to pay its debts regardless of the financial effect of COVID. This ban on winding up petitions is until the 30th of September. But now that the government's extended the forfeiture moratorium, we're expecting that there will be an extension on this ban on presentation of winding up petitions similarly to the 31st December. But what we're interestingly seeing is a huge rise in the number of retailers and restaurant groups entering into what's called a company voluntary arrangement. This is a statutory procedure which is intended to assist in the rescue of a company in financial difficulties. What it does is it allows a company to agree an arrangement with its creditors in satisfaction of some or all of its debts. And they are generally used to restructure leases of underperforming properties. I think this is, I mean, we have got so many company voluntary arrangements that are sort of going through at the moment, and I think that's going to be the trend for the foreseeable future. I mean, effectively, you know, retailers and restaurant groups are able to use this process to get rid of their underperforming restaurants or units rather. So it is a very useful tool, but I think we're going to see some kickbacks from landlords resisting this.
Sure. Well, in the U.S., we've certainly had a lot of retail bankruptcies, and while some of them are going through a similar process that Amanda explained as far as restructuring, the vast majority of our bankruptcies here are going out of business. Companies that were already probably declining, and that this just really accelerated the process. A lot of retailers, we've had a lot of turnover in the retail business in this country as far as changing away from big box retailers and anchor stores to malls to more experiential retail, as we call it. And that is being accelerated by COVID. A lot of companies that have been around for a long time or were trying to hold on, they can't survive this. And there's some other companies that were doing okay and could have survived for a few months, but now that we've really gone past a few months with no foreseeable end, with retail still struggling, we're seeing a lot of companies not being able to make it. One of the more interesting ripple effects throughout our country is that some of the big owners, the real estate investment trusts or the big mall owners, are buying their retailers that otherwise would be going bankrupt, or buying them out of bankruptcy. So they're now not only going to be the landlord, but they're going to be running these big retail chains. And that keeps them from, as we say, going dark and having big dark spaces in your malls. They can keep operating them, and maybe they can save on some costs, but it's a big risk for these companies whose business is not the retail business. They're in the commercial real estate business. So that's a fairly new phenomenon that we're seeing happening to keep some places operating, and we'll have to see how that plays out. So that's really what's going on here in the U.S. as far as bankruptcies. There's a lot of it.
Thanks, David. What I wanted to suggest, given that we have less than 10 minutes till the end of the session, what if we skip the insurance slide and combine the last two slides, negotiations and the new landscape, to discuss what's going on now and what's going to happen in future, what are our prognosis related to post-COVID real estate leases. I understand that Amanda has this case, and insurance case, I mean, and I think that Amanda, you should speak up and share the success that you recently had.
Yeah, so in relation to the insurance, a test case was brought by the Financial Conduct Authority, representing the interest of policy holders, which are mainly small to medium-sized businesses. The purpose of the case was to determine issues of principle on policy coverage and causation under sample insurance wording. So hot off the press this week, in fact only on Tuesday, the court, it's our High Court, found in favour of the Financial Conduct Authority on the majority of the key issues, and in particular in respect of coverage triggers under most disease clauses. So this is so effectively they were saying that the coverage isn't limited to physical to damage to physical property, but also to non-physical damage, i.e. loss of profits. I mean, this is welcome news to a significant number of the thousands of policyholders who have been impacted by COVID. However, it's anticipated that the insurers will appeal this decision. So, I mean, it's really going to be a question of watching this space. But it seems as though the decision of our High Court is at odds with the view of the courts in the US.
Yeah, thanks, Amanda. before we go on to our ordinary course of discussions, I know that one of the participants of the session, Sergei Lysov from Kulkov, Kolatilov and Partners, had something to share on his experience in lease negotiations. So, Sergei, if you are with us, can you share your experience, please?
Yes, can you hear me?
Yep.
Great. Yeah, thank you. My name is Sergei Lysov, and I'm a senior associate with Kulkov, Kolatilov and Partners. I just wanted to highlight that recent trends on the slide. You can see that in Russia we prefer litigious approach, and that is entirely true. However, recent trends in the lease agreement demonstrated that this approach is far from being ideal, because, for example, as Andrey correctly mentioned before, the law indeed allows to reduce the amount of lease payment in case of dispute in this respect arises. However, I briefly analyzed recent case law of Moscow courts, and I've seen none of positive decisions for tenants, where the price or where the lease payment has been decreased. Various reasoning had been used by the court, but there was one general line that it hasn't been proved that the situation has been onerous and led to impossibility to use the immovable property. Therefore, I think that now the recent trend after coronavirus demonstrate the necessity to develop mediation, the mediation in Russia, because the mediation institute has been underestimated during recent times. And of course, in commercial courts, we have a mediation rooms and etc. But I've never seen people leaving this room and shaking their hands in the suits. Therefore, I think that litigious approach, taking into account the negative case law, will lead to the development of mediation and negotiation instruments between the landlord and tenants. So hopefully coronavirus will be a positive start here.
Yeah, yes, Sergei, I really support that. Thanks a lot for sharing your thoughts, and I really hope that what you're saying would become true. We also did some case research, and we found cases in Russian regions where tenants have prevailed on asking an abatement for lease and then termination. But generally, I agree with you that the situation we're all in provokes new approach and new approach to risks on both sides, the tenant and the landlord. And with this thought, I suggest we go on to the new landscape slide, and with the 3 minutes left, David, Amanda, and Aleksandr would share their views on how the landscape will change actually.
Well, just real quick, because I know we're on our last couple of minutes, I think the biggest change in the retail world is that to be successful, you've got to develop app-based and internet-based channels of selling your goods, if that's at all possible. I've got some retail clients that have met their numbers from last year by really doing that, and so that to me is the biggest takeaway of how things are changing here as a result of COVID.
Mm. I think in the UK, what we're going to see is a real shift in the dynamics of the landlord and tenant relationship. I think up until now, it has always been a sort of regarded as a master-servant relationship, you know, that they're opponents. I think that there is going to be more partnership, sort of more collaboration. I think that, you know, in terms of sharing the risk, to a greater extent, our leases, the rent is a base rent. It's a market rent. I think going forward, we're going to see more what we call turnover rent. So it's rent based on the turnover generated from the property, or a mix of where there is a base rate and then turnover on top of that. I think in terms of internet, I think that there is still going to be a need for physical properties, but I think tenants are going to want smaller premises which are effectively going to be a shop window, and whether it's for click and collect, but I think that there will be a need for smaller units, but still a need for units.
Yeah, I do agree with both, with David and Amanda, and I think that since many of the tenants could not survive during this crisis in many of the countries in the world and in Europe as well. So with respect to the future, now I think the rent rates will go down because there are more rental spaces in the shopping malls, in the street retail as well. And with respect to the online, I will give you just a very simple example. Mango has about 1,500 shops all over the world. So during let's say, starting from the middle of March and until, let's say, May, 95% of them were closed. The physical stores were closed. And last year, Mango invested a lot in developing its online sources and online platforms. And this helped a lot the company, a lot, really. I cannot share you the figures, of course, but this was something, I mean, I was really amazed because it was a boom in many of the countries. Also in Germany, for example, or even in Russia, people start buying, being confined more than ever. So so I think this will also continue growing.
Yeah, thank you very much, colleagues. I think with this, we shall be closing our session. It's good to know that online has its future, but especially speaking at this conference this year, I feel that I really miss the offline format of communicating with everyone face to face. So let's end our session with a hope that next year we'll be able to meet in person in Moscow. Thanks a lot.
Thank
you. Thanks. Bye.
Bye. Okay, so it's interesting that we were not switched off automatically. So there was no countdown.
So shall we leave the room? Shall we leave the conference?
Well, I'm not sure, actually. I think we can discuss something. I see that there are some attendees there. So as long as we're not switched off, maybe we have some questions, some attendees want to ask something. I see that Glenn is here. Glenn was here. Okay, guys, I think we can arrange a call in a day or so to have a short discussion afterwards. But I really enjoyed the session. Thanks a lot.
Yeah, it's brilliant. Thank you. Take care. Bye.
Bye-bye.
Bye. Bye-bye.